Given the circumstances, at least as I understand them, and because I haven't.
Every single day in courtrooms across America, lives can change in minutes, sometimes seconds. And today's case is one of those moments where procedure, ego, and consequences collide in real time. What you're about to witness is not just a legal hearing, it's a slow motion unraveling. We have a defendant charged with serious offenses, choosing to represent himself, walking into a courtroom clearly unprepared for the gravity of what's coming next. On the other side, a judge who is calm, methodical, and very clear about one thing: courtroom decorum is not optional. This case immediately raises red flags, not just legally, but strategically. When someone decides to go pro se, meaning they represent themselves, the court gives warnings, but it does not give mercy, and that's where tension begins to build. Because what happens when confidence turns into confrontation? What happens when frustration spills over into disrespect in front of a judge who controls your freedom? Stick with this video, because what starts as a routine proceeding quickly escalates into warnings, bond violations, and a defendant unknowingly talking himself deeper into trouble. Watch closely. The smallest statements here carry massive consequences. And ask yourself early, would you ever represent yourself in a case like this? Or is this already a losing move?
Heard the entirety of the case or anything.
Right, exactly.
I'm
Probably
going,
was or anything.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes this hearing. Court does call the case. The people of the state of Michigan versus Cody Lee Jolly. We're actually set for, what are we set for? We're set for PCC. All right, state your name, sir.
Cody Lee Joe.
All right. Mr. Jolly, are you still intending upon representing yourself? All right. I do have to apprise you that in this matter, you were charged with 2 offenses versus criminal sexual conduct in the 4th degree. Well, 2 counts as criminal sexual conduct in the 4th degree. You understand the nature of those charges? You understand the allegations as explained to you during the course of the arraignment in these cases? Okay. The maximum penalty, those are both high court misdemeanors punishable by up to 2 years incarceration.
This is where the case becomes very real. 4th degree criminal sexual conduct may be classified as a high court misdemeanor, but let's be clear, this is not minor. 2 years of incarceration per count, fines, court costs, and mandatory testing are all on the table. And beyond sentencing, the long-term consequences can follow someone for life. The judge does something important here. He methodically explains the risks of self-representation. And this isn't legal theater, it's protection. Courts do this to prevent appeals later. Once the defendant says he understands, the record is sealed. No undo button. Notice the pattern forming. The judge repeatedly asks, "Do you understand?" That repetition isn't impatience. It's documentation. Every yes removes future excuses. Here's the uncomfortable question for viewers. If a trained judge is openly concerned about your ability to defend yourself, why push forward anyway? Confidence in court is not competence. And in criminal cases, the margin for error is razor thin.
$500 fine plus court costs, mandatory STD testing. You understand that, sir?
Yeah.
All right. You understand that there can be great peril in attempting to try to represent yourself in a criminal matter of this nature? And you understand that the court would hold you to the same standards as I would any licensed attorney in terms of court rules and in terms of court procedure. You understand that? And you understand that the court is not going to try to assist you or help you out in any way? All right. And you understand also, sir, that if you are indigent and cannot afford to hire an attorney, that you would be afforded counsel and could request counsel at any particular time. You understand that?
Yeah.
Okay, very good. All right. So what are we going to do in this case?
Your Honor, I'm covering this case for Ms. Reiser today. She did provide me with the outstanding CD of discovery for the defendant. I understand that the police report has already been sent out to him by mail. And the CD provided to the jail staff.
Yeah.
If the answer is no, I don't have that. Could you put it in? Is that acceptable? Is that okay with you guys? Okay, thank you so much.
All right.
So that's
Oh.
everything we have.
All right. That's all discovery. Sir, what did you want to do next on this case?
Before I start the trial.
Well, you understand that the next step is not that of a trial?
This moment exposes a major problem, and the judge sees it instantly. The defendant doesn't understand basic criminal procedure. Trial isn't next. There are steps before that: probable cause conference, preliminary examination, potential bindover to circuit court. These steps determine whether a trial even happens. And here's why that matters. Missing or mishandling these stages can lock in damaging evidence, waive rights, or eliminate negotiation opportunities. This isn't just a knowledge gap. It's a strategic disaster waiting to happen. The judge's concern isn't condescension, it's foresight. Courts don't slow down because someone is confused. The process moves forward whether you're ready or not. Audience question here. Should the court step in more when someone clearly doesn't understand the process? Or is personal responsibility the final line? That tension is at the heart of this entire case.
Is this pre-trial?
Oh, okay.
I understand this is pre-trial and we're on the trial.
Mr. Jolly, do you really wish to represent yourself in this matter? I'm a little bit concerned because you don't. Well, but that's not how it works. Okay? That's what concerns me. You're charged with a high court misdemeanor. Okay? The next step is that we're at a probable cause conference. The next step is a preliminary examination. Okay? And then if you're bound over, then you're going to go through that process once again on the circuit court level. You follow that? Okay, so now understanding that that's a basic procedure, what do you want to do?
Just move forward and just not guilty and case with preliminary examinations. It's okay. I have this matter I'm in custody right now. And I was hoping to settle to solve it.
So you want it, you got a copy of the police report, right?
I got the discovery. I did, it was emailed to me.
Okay. So you want a preliminary examination in this matter?
If that's the next step to move on to trial, then I'm trying to get the trial done as fast as possible, but if the preliminary examination goes before that.
Wow. And all right. I know, but if it has to break, we just have to break.
Yes, sir.
All right. Set preliminary examination for April 23rd.
Setting a preliminary examination is not procedural fluff. It's pivotal. This hearing determines whether prosecutors have enough evidence to move forward, and it's one of the most important opportunities for defense strategy. But here's the issue. Without counsel, defendants often don't know how to challenge probable cause, cross-examine witnesses, or suppress weak evidence. This is where experienced attorneys create leverage, and where self-represented defendants often lose it. The judge is being precise, patient, and deliberate. Everything is now on the record. Dates, times, expectations. There's no ambiguity left. So ask yourself, is this defendant prepared to challenge evidence, or just eager to move fast without understanding the cost? Speed in court doesn't equal success.
2024, 9 a.m. That will be before me. That's in person.
In this matter, the prosecutor puts it in.
Pardon?
Is, the other day I went to the arraignment. I was hoping that to get released, but there was, I had to come here first. Can I get released through
What do you mean? You?
He was arrested. My office had a new warrant request for him from the University of Michigan. It was for trespass and for violating the conditions of Your Honor's bond and that you said in this file. He has been trespassed from the University of Michigan libraries numerous times. He was again there, which is where he was
Nice,
arrested on April 5th, 2024. He was publicly looking at inappropriate photos of women.
This is where the stakes explode. A bond violation changes everything. The prosecutor isn't just alleging misconduct, she's describing behavior that violates court-ordered conditions. And bond conditions are not suggestions. They are legal restraints tied directly to freedom. Even without new charges, violating bond can land someone right back in custody. And notice something critical. The defendant is on bond for sexual conduct charges, and the alleged behavior occurs in a public university library. Context matters. Judges don't view violations in isolation, they evaluate risk. Here's the key takeaway. Bond is trust. Once broken, judges reassess everything. And admitting violations, especially without counsel, can be devastating. Viewer question: would you have admitted anything here without a lawyer present? Because admissions echo loudly in court.
In the school library, and other people were able to see what he was doing. He was reported when the police came. They recognized him. They recognized him as the person that they had trespassed times. The report indicates that his shirt was open, exposing his chest, and that his pants were pulled down, but that his genitalias were not exposed as far as they saw. Certainly this is the CSC. He's out on bond in the CSC case while he's engaging in this behavior. At the very least, the ongoing trespass is violation of his bond, given that he's committing a new crime while he's out on bond, and that concerning behavior engaging in a public place, in a place he's been trespassed. My office denied the warrant request and essentially turned to this case and for us to move forward on violation here instead.
All right. Sir, you are entitled to a hearing regarding a bond violation on this matter. Did you want to have a hearing on that? Did you want to admit the violation, or did you want to deny it? What do you wish to do?
To admit the violation was what again? I'm sorry. The violation was because when I got here, they told me that everything was. They said that it was when they came out and gave me the trespass when I got here. They said the trespasses and stuff, and they weren't worried about it. It wasn't.
Well, they weren't worried about it from the standpoint of new charges.
Okay, yeah.
But my understanding is that the prosecutor doesn't want you released because what the conduct that's alleged to have occurred is a violation of the condition of bond on this case.
Okay, yeah, there was nothing inappropriate besides being in the library. Yeah, nothing weird in the library. I have no idea. But yeah, I wasn't.
But you weren't supposed to be back on on the property.
That's what they said. I guess that was stemming from this. So,
Do you want a hearing on it? Or are you going to admit to the violation? What are you going to do? You're entitled also, sir, to have a representation of an attorney for a bond violation here.
but I mean, if it's not a new charge, I admit that I was trespassing. That I was probably trespassing there. I was hoping to get out of jail for days.
Well, I need you to understand that I'm not agreeing that you're going to get out of jail at all. Whether you admit it, do whatever, I'm not.
Right.
Well, you just admitted to the violation. That's why
This is the moment legal professionals wins. The defendant admits the violation, seemingly without grasping the consequences. Admissions eliminate debate. They narrow options. They hand leverage to the court. The judge's tone shifts here. He's no longer just explaining. He's concerned. And that concern is warranted. The defendant has now created a record against himself. Judges cannot unhear admissions, and even if intentions were misunderstood, the legal effect remains. This raises a hard truth. Self-representation doesn't just risk mistakes, it locks them in permanently.
worried about you not having an attorney. Just you admit to the violation of being on University of Michigan property, correct? Okay, so that's why I'm worried about you not being represented by an attorney. Because that's a violation of the bond conditions that I set in the case involving the criminal sexual conduct.
I've never been there before. I wasn't aware that I wasn't allowed to be in a public library. I've never been in the building before.
Sir, did you want a hearing on the bond violations? Because I'm going to take into account everything that they're indicating, that you were trespassing and what was in there. Do you want a hearing on that?
Yes.
Do you want an attorney to assist you regarding that hearing on the bond violation?
I think I'm okay. I just the bond and stuff we can get it heard. Simple as that. I've done 10 days in jail already. And
Where are you coming up with this 10 days in jail?
just got and
Yeah, but what do you mean I've done my 10 days?
I've been 10 days so far, and I've not actually had the charge. I've been charged with these 2 counts that are here, but I've not actually committed the offense.
Okay, but sir, you understand that the criminal charges that are here, that your release on those criminal charges, there were certain conditions regarding your release.
Right, that's what they're telling me.
Correct. In certain places you couldn't go, you couldn't leave the state of Michigan, no alcohol, all of that stuff, right?
The best I can. I've been 2 months without a problem. The best I can.
Okay, but now I have I have a trespassing, which is a violation of the conditional, your release. And I could, if there's a violation of the conditions of your release, I could certainly let you out. I also could just hold you until this.
This is judicial transparency at its clearest. The judge spells it out plainly. Release is possible. Custody is also possible. And the bond violation hearing will decide which path becomes reality. The defendant still insists on handling it alone. That decision now carries maximum risk. This is no longer about pride. It's about liberty. Audience engagement moment. At this point, would you stop everything and request counsel, or push forward anyway? Because this decision could mean walking out or staying behind bars until the case ends.
Matter gets resolved. You understand that? And now you want a hearing on that. And that's fine. I don't have a problem if you have one, you're gonna have a hearing on it. But then the issue becomes, are you gonna try to handle this hearing yourself? Or are you gonna want an attorney to assist you with that? I understand that you want to move forward, but there's gonna be a hearing that's going to determine whether or not you're in custody. Pardon?
As soon as possible.
Well, I haven't set a date. I'm trying to figure out how you want to proceed on it.
Just like I said, I'm just doing my best to live my.
Sir, I understand all of that. Listen closely to my question. This hearing on the conditional bond violation could determine whether or not you're in custody or you're released with other conditions or not, pending the further proceedings in this case. Bottom line, I could come to the decision, okay, well, I'm gonna let him out, put conditions on you and you walk out. Or I could come to the decision, no, he's gonna be held on this case. I'll give him a bond of some type, but he's gonna be held. Okay, but you understand what I'm saying?
Yeah.
You'd be held. That's what's at stake.
Yeah, just hope the as soon as possible. So I just like to move forward.
Well, I understand that, but follow what I'm saying to you. You say you want a hearing. My question to you is, are you going to try to do this hearing yourself? Where one side of it, you might get released, the other side of it is you might be locked up for the remainder of this case. Do you want to try to do that yourself, or do you want the assistance of an attorney to help you through that process?
I think I just hope that just facts.
Just answer my question. You're gonna handle it yourself. Okay, but you're going to handle it yourself. How soon could we have witnesses available for a bond violation here?
The answer to that question, I apologize.
No, it's okay.
Are you thinking like a week? Is that what you mean?
I'm thinking sometime next week, and then, because the following week is his, what day?
So we would have Tuesday morning available,
The
but
16th.
he's in custody, so I would do that. Because that's pretty limited, he's in custody. Once we did it,
What, I got stuff Tuesday afternoon.
we have an expungement docket at 1, which is small, so you can do it at 2:00.
I could do it at 2:00 on Tuesday, the 16th.
It's a U of M police officer, so I can email him, to U of M police officer, so I can email them and see if one or both of them can be there on that date.
Okay, what I'll do, I'll just set it. If there becomes a problem, we'll communicate with the defendant as well as you, just try to arrange a different time. So set a bond violation hearing, April 16th.
Once the hearing is scheduled, the clock starts ticking. There's no more debating what happened, only whether it violates bond conditions and what consequences follow. The defendant mentions time already served, hoping it counts. But courts don't trade days for violations. Each matter stands on its own. This illustrates a common misunderstanding. Jail time doesn't cancel pending procedure. Everything must still be addressed formally.
2024 at 2 p.m.
Mhm.
At 2 p.m. Is there anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tender condition. because this, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Yeah, I can't afford cash bonds, just right, be around on maybe time that I've got it, you know.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you.
This case is a textbook example of why courtroom procedure matters just as much as charges themselves. The defendant faced serious allegations, chose to represent himself, misunderstood key legal stages, admitted to a bond violation, and now stands at a crossroads where freedom or continued custody hangs in the balance. Judge Simpson maintained professionalism throughout, issuing warnings, explaining consequences, and ensuring the record was airtight. The broader lesson here is simple but powerful. The justice system does not bend to confusion or confidence. It responds to preparation and procedure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.